consideration and future consideration is also valid. Then fourth one is consideration must be real and not illusory one. It should be a real one. Illusory consideration shall not be treated as a valid consideration. Then consideration may consist of an act, an abstinence, or promise. An act to do something or not to do something, withdrawing from doing something. See, that will be treated as even an act to do or not to do something, or abstain from doing something, that will be that abstinence also will be treated as a valid consideration. Consideration must be lawful. Illegal consideration is shall not be treated as a valid consideration. Then next one, consideration need not be adequate to the value of the promise. Something, this is consideration means something in return. It shall not be, need not be adequate to the value of the promise, whatever the promiser is made. It need not be adequate. Something in return, even something, even a detriment, that will be treated as a promise. And the next one is a case study showing the consideration must move at the desire of the promiser. There is one case study called as Durga Prasad versus Baldio. See, in this case, Baldio spent some money on the improvement of a market at the desire of the district collector. And in consideration of this, Durga Prasad, who was using the market, promised to pay some money to Baldio. See, in this case, the agreement was void, being without consideration, because the first agreement, this is related to the reconstruction of the market or improvement of the market. It will be done by the government only, and the contract between this Baldio and the government, the offer regarded by the district collector only. So, and at the same time, whatever agreement made by Durga Prasad and Baldio, this is not valid, because that agreement is without consideration. So this agreement is void ab initio, mainly because of lack of consideration. The next one is, the consideration may move from the promisee or any other third person or any other person. There is one case study called as Chinnaya versus Ramaya. See, this is a case study. An old lady, by a deed of gift, made over a certain property to her daughter under the direction that she should pay a certain amount to her aunt every year, a certain sum of money annually. The same day, there was an agreement between daughter and her aunt regarding the payment of this amount. Later on, daughter of this old lady refused to make the payment, arguing that there was no consideration regarding the second agreement. So the court held that in this case, consideration need not be from the promise itself. Even from a third party, consideration is also valid. So in that case, the second agreement is also valid. That means the daughter of that old lady should comply that agreement between that lady and her aunt. That means she should pay amount, whatever she agreed during at the time of agreement, she should pay that amount annually. This is a valid agreement, because the consideration received from the old lady, that is valid for executing the second agreement, even though without consideration. So consideration may be moved from the promisee or from any other third person or any other person. The next one is, there are certain exceptions. The general rule is no consideration, no contract. But there are certain exceptions to this rule. Section 25 of the contract 1872 defines, in the following cases, an agreement would be enforceable even without consideration. The first one is love and affection, natural love and affection. An agreement without consideration is enforceable according to section 25. See, these are the exceptions to the general law of no consideration, no contract. So according to this section, these are the exceptions. First one is love and affection. See, an agreement without consideration is enforceable if it is made out of natural love and affection, and that love and affection is natural because the parties are so related to each other, and that agreement is in writing and it is registered. So suppose an agreement without consideration, for example, out of natural love and affection, see, that agreement is valid even though without consideration, provided that it should be made out of natural love and affection. The natural love and affection means the parties are, the love and affection between the parties are so related to each other, and that agreement is in writing and it should be registered. Suppose the agreement is fulfilling all these conditions, and a contract without consideration is also valid because of natural love and affection. The second exception is, we can say, a compensation for voluntary services. So any compensation paid for voluntary services done by any other person, such contract is also valid. And promise to pay time barred debt. So time barred debt means a debt which are irrecoverable within a stipulated period of time. In India there is one enactment called as Limitations Act. According to the Limitations Act, in generally we can say, suppose a person who is not collecting his debt within a stipulated period of time, usually 3 years, that debt will be called as a time bar. See, later on, suppose the other party is remitting that money to the other person. So in that case, that agreement is valid even without consideration. So promise to pay a time bar debt is also a valid consideration. The fourth one is in order to create a contract of agency. According to section 185 of the contract in 1872, no consideration is required to create a valid agency. Okay. So the next one, we are talking about the exceptions to the rule of no consideration, no contract, section 25 of the contract in 1872, and we discussed some points like out of natural love and affection, suppose we are making any gift, see, that is valid because of natural love and affection, and it should comply certain formalities that like it should be in writing and it should be registered. The next one is compensation for voluntary services. No consideration is required, and promise to pay time barred debt, no consideration is required, it is valid. And next one is in order to create a contract of agency, section 185, no consideration is required to constitute a valid contract of agency. Then last point of exception, we can say a gift already made. See, a gift actually made is valid. Nothing in this section shall affect the validity as between the donor and donee of any gift already or actually made. See, whatever gift already made, there is no question of consideration. Even without consideration, it is valid. See, these are the exceptions to the general rule of no consideration, no contract. The next one, we are entering into section 23. According to section 23, this is unlawful agreements, the agreements which are expressly declared to be void, section 23. So the following cases, we can say some agreements are expressly declared as void. According to section 23, the consideration or object of an agreement is lawful unless it is forbidden by law or is of such a nature that, if permitted, it would defeat the provisions of any law, or is fraudulent, or involves or implies injury to the person or property of other, or the court regard it as immoral or opposed to the public policy. See, this is the definition of section 23 regarding unlawful agreements or unlawful contracts. So according to section 23, a consideration or object of an agreement is lawful unless if it is forbidden by law or is of such a nature that, if permitted, it would defeat the provisions of any law, existing law, or is fraudulent, or involves or implies injury to the person or property of another, or the court regards it as immoral or opposed to the public policy. See, these are, so we can say these are the cases in which we can say the consideration is unlawful, or object is unlawful, or that agreement, in shortly we can say that agreement is unlawful. The first one is if it is of such a nature that, if permitted, it would defeat the provisions of any existing law. So in that case, we cannot create any kind of a valid contract for that specific purpose, because if permitted, it would defeat the provisions of any existing law. Or second one is if it is expressly forbidden by or prohibited by law. The third one is if it is fraudulent, that's such kind of agreement fraudulent in nature. Then fourth one, if it involves or implies injury to the person or property of another, or if the court regard it as immoral or opposed to the public policy. See, these are the cases, 5 points of 5 cases we can say the object of that agreement or consideration of that agreement is unlawful, and it will never create any kind of valid obligation or a valid contract. See, the next one is the sixth one, the court regard it as opposed to the public policy. Some agreements or some offer and acceptance, promise or agreement expressly it is declared as opposed to the public policy. The following are the some of the examples of the specific agreements which are expressly declared as void, or which are expressly declared as opposed to the public policy. The first one is trading with an enemy. Second one is agreement for stifling prosecution, agreements interfering with the course of justice. Then next one is agreement tending to an abuse of legal process, agreements to vary the period of limitation, the traffic in public offences. Then agreement creating an interest opposed to duty, agreements restraining personal freedom, agreements opposed to parental rights and duties, and marriage brokerage agreements. See, these are the agreements which are expressly declared as void and which are opposed to the public interest or public policy. See, these are the discussions about consideration. The next one, we are entering into another important topic called as competency to enter into a contract. So who are the people or who are competent to enter into contract? Section 11 of Indian Contract Act 1872 defines the competency to enter into a contract. According to Section 11, every person is competent to contract who is of the age of majority according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. See, this is the exact definition of Section 11 regarding the competency to enter into a contract, or capacity to enter into a contract. According to Section 11, every person is competent to contract who is of the age of majority according to the law to which he is subject, is of sound mind and is not disqualified from contracting by any law to which he is subject. So the following persons are incapable to enter into a contract. The first one is a person who has not attained the age of majority. That means a minor. A minor is not capable to enter into a contract. An agreement with a minor is void ab initio. So the person is incapable to, minor is incapable to enter into a contract. The second one is a person who is not sound mind. That means unsound mind. The unsound mind is we can say see a lunatic person. A lunatic person is or a drunkard person. He is facing some kind of temporary incapacity. See, some unsound person is not capable to enter into a contract. And third one is a person who is disqualified by any other law to which he is subject. Some people are expressly declared as disqualified to the law to which is subject. See, these are the qualifications of competency to enter into a contract. So the following persons are incapable to enter into a contract. For example, the minor is incapable to enter into a contract, an unsound person is incapable to enter into a contract, and the specific persons which are expressly disqualified from contracting by any law to which is subject is disqualified from or incompetent to enter into a contract. Then let us see one by one the minor, an unsound person, and the other disqualifications. The first one is minor. So who is a minor? So the term minor is nowhere defined in the Contract Act 1872, but the section 3 of the Majority Act 1875 defines a minor is a person who has not attained the age of 18 years. See, a Contract Act is not defining the term called as minor, but the Indian Majority Act section 3 of the Indian Majority Act 1875 defines who is a minor. See, a minor is a person who has not attained his 18th years of age. But in the following cases, some exceptions is there. In the following cases, the minority will continue up to 21 years of age. The first one is where the guardian to a person or property of a minor is appointed by the court. And second one is when the minor is under the guardianship of the court of wards. See, in these cases, is minority, he will become major only after the completion of 21 years of age. Generally speaking, the person become major whenever he is completing his 18th years of age. But there are two exceptions, like whenever the court appointing some guardian for his property or the person or the property as per the Guardians and Wards Act. So in that case, his minority will go up to 21 years of age. And the rules, and the next point is rules relating to an agreement with a minor. What are the legal position related to the minor's agreements? The first one is an agreement with a minor is void ab initio. Ab initio means at the beginning itself. So an agreement with a minor person is void ab initio. The second one is minor can be a promisee. A minor can be a promisee. Then the next one is minor's agreement cannot be ratified. No compensation is payable by a minor, and the rule of estoppel does not apply to a minor, and no recovering back the money paid. We are talking about the legal position or rules related to the minor's agreement. The first one is minor's agreement is void ab initio. At the beginning itself it is void, and a minor can be a promisee, and a minor's agreement cannot be ratified. It cannot be ratified after becoming a major person, or no one can ratify the minor's agreement, and no compensation is payable by a minor. The rule of estoppel does not apply to a minor case, and no recovering back the money whatever paid. See, there is one case study regarding this point. No money paid, no money recoverable whatever paid to a minor, or minor's agreement is void ab initio. The case study is called as Mohir Bibi versus Dharmas Ghosh. So minor's agreement is void ab initio. This is a case. A minor mortgaged his house property in favor of a moneylender to secure a loan of rupees 20,000, out of which the mortgagee paid to the minor a sum of rupees 8,000. Subsequently, after getting the majority of the minor, he filed a case against the mortgagee, claiming that whenever executing that contract, he was a minor. So court held that this agreement is void ab initio, that mortgage is void and it is cancelled. But so further the mortgage he pleaded in front of the court regarding the repayment of 8,000 advance whatever he paid to the minor. So court held that whatever amount you paid to the minor, it shall not be recoverable, because the minor is not liable for reinstating whatever amount he took as advance. So this is a case study of minor's agreement is void ab initio, and the money whatever he paid in favor of a minor is not recoverable. The next one is a minor can be sued in case of tort. And a minor can become, as per the section 185 of Indian Contract Act, a minor can become an agent, because the responsibility of the Minors Act as an agent, it is vested in the hands of the principal only. So he can act as an agent. And regarding negotiable instrument, minor can make and deliver negotiable instrument. And regarding Partnership Act, a minor can be admitted into partnership only for the benefits, only for profit. So that means a minor can act as a partner for profit only. And regarding the Companies Act 1946, no minor can, a minor is barred from holding any shares in his own name, but the guardian can purchase shares on behalf of a minor. See, these are the legal position. So minor can be sued for tort, an agency, a minor can act as an agent, negotiable instrument, a minor can prepare and deliver negotiable instrument. Regarding partnership, minor can become a partner for profit only. And regarding the Companies Act 1956, no minor can become a shareholder or a member of a joint stock company, but the guardian of the minor can purchase shares on behalf of a minor, even if the name of the minor is recorded in the register of members. That is not valid, because a minor is not in a position to possess or purchase shares. The next one is insolvency. A minor is incapable to enter into a contract, so minor cannot be adjudged insolvent or bankrupt, nor can his properties be attached for the outside liabilities. The next one, minor as a trade union member. A minor over the age of 15 years but below 18 years